welcome to so many of you to our session on lessons to be learned from the residential schools investigation of IICSA. I'm joined today by Natalie, and the pair of us have been working on the inquiry since 2016, when schools were first asked to provide information to the inquiry. Some schools were, and we've also represented two organisations through the process. We've been living and breathing the inquiry for all of that time and waiting with bated breath for the report. And this is our initial observation on the report and lessons to be learned, and also we'll spend some time talking about what we expect in the future and what we were surprised perhaps weren't covered in the same level of detail as we had expected. So the format for today is that Natalie's going to take us through the background to the inquiry. I'm then going to talk about our observations, and then we'll have some Q&A, and we'll hope we'll get through all of those for you. Okay, over to you, Natalie.
So hello everyone, and again, thanks for joining us. As Tabitha said, we have been living and breathing IICSA since about 2016, but even further back than that, we've been dealing with historic issues and helping schools to navigate the minefield that is dealing with these sorts of historic claims and safeguarding issues. But just a basic sort of background to the independent inquiry into child sexual abuse, in case you've been living under a rock for the last 7 or 8 years. So it was set up in 2015. There have been 15 investigations and on various sectors and themes, and they have produced 19, not 9 reports. Apologies for that on the slide. And many of these investigations have considered issues related to schools, particularly those conducted as part of the religious organisations investigations. But the final investigation was into the was called the residential schools investigation, albeit that it actually looked at both day and residential schools. Now, we will come on to what we expect in the future, but the final report is expected in 2023, which will be across all the investigations. So moving on to the background to the residential schools investigation itself. So concerns were raised about 160 schools, and the inquiry saw evidence from 75 schools, and then focused on 21 schools over 2 hearings. Now, phase 1 covered music, residential and closed schools because of the particular risk factors presented in those schools. And phase 2 took a thematic approach, looking at safeguarding in both day and boarding schools, both in the state and independent sectors. And as Tabitha said, we represented core participants in both phase 1 and phase 2. If we move on to the next slide. So on the 1st of March, the report was published. Tabitha and myself were waiting with bated breath to see what the report covered. This is a copy of the press release. And I think it just gives a good flavour of what the report covers. And I think there's no getting away from the fact that some of the content is quite shocking, and it's not just in the distant past. There have been some more recent allegations of teachers exploiting their positions at trust and grooming children across all different types of educational settings. And sadly, the conclusions are that schools are not as safe for children as they should be, and that unfortunately children's interests did not always come first when allegations of sexual abuse are made, and that children continue to experience sexual abuse and sexual harassment. And so, I mean, we've seen this through Everyone's Invited, it's a recurring theme that unfortunately in this day and age, sexual abuse and sexual harassment are part of the issues that schools have to deal with on a pretty regular basis. So in terms of the report itself, as I say, it was published at the beginning of this month. It considered evidence from survivors, staff, local authorities, inspection bodies, and some specific case studies. It's really, really detailed, over 220 pages. And I'm sure many of you will have read the report or part of it. But the executive summary and the conclusions do make really, really essential reading. And as I say, it makes quite a tough read. You know, even myself and Tabitha, we've dealt with hundreds of different allegations over many years, and it still shocks us to see the allegations of abuse and the extent that offenders will go to find ways to abuse children in any settings, but in this instance in schools. So if we move on to the next slide, the case studies illustrate themes which have emerged across the sector. And the investigation explored how schools and other agencies responded to these allegations. But they also looked at broader questions of school culture, governance, leadership, training, and recruitment. So on the next slide, the findings were that there were multiple issues, multiple institutions were implicated in failures in child protection, including many of those partners that you will be working with, so local authorities, the inspectorate bodies, the police. And the investigation took into account the wide spectrum of responsibility across all of these organisations, you know, who have responsibilities under working together and keeping children safe in education. So one of the areas that IICSA focused on was the weakness in the existing safeguarding system and trying to close some of these loopholes in the legislation and guidance, the issues with your dealings with LADOs, and I'm sure many of you have experienced some frustration in terms of your dealings with the local authority designated officer, and also the cultural issues around sort of lack of appreciation or acceptance of what has happened in the past and unfortunately continues to happen in some schools in terms of sexual abuse and sexual harassment. And one of the things that came through loud and clear is about the cultural shift that's required and that need to accept it could happen here. Now, this is not new. We've seen this in Keeping Children Safe, but the case studies really, really do hammer that home. That gone are the days where, you know, it's okay to say, well, so and so was a good bloke and he was a really good teacher and he was really liked. That's just not going to be sufficient. We really do need to take all allegations very, very seriously, as I'm sure you all would. And in the case of harmful sexual behaviour, in the wake of Everyone's Invited, schools need to really accept that it probably is happening here. And so, you know, fundamentally, there's no single simple solution to it. And IICSA is looking for the government, DFE, to implement some incremental changes across a number of different areas to try and improve the existing systems of protection. Now, I think we have to be realistic here that there still would be those individuals who may seek to offend, and we're never going to be able to completely eradicate this risk, but how schools respond is absolutely key here. And all the research indicates that a really good safeguarding culture can deter offenders and enable victims to come forward. So if we move on to the recommendations. So there were 7 recommendations made. They're set out on the slide. In relation to residential schools, there was some focus on introducing a duty on all residential schools to inform the inspectorate of child sexual abuse. So to go further than Keeping Children Safe currently goes. And there was a lot of focus on issues in residential special schools. So changes to the regulatory framework to level up, particularly in relation to this situation where some schools will be inspected against the higher quality standards for Ofsted, for children's homes, rather than the lower national minimum standards. So I think we can expect to see some changes around that. And also looking at these issues around the licensing and regulation for educational guardians. And again, some of the case studies and the stories that you would read in the report in relation to how educational guardians use their positions to exploit children is truly a very difficult read. The second recommendation relates to responding to allegations and concerns. And as I've mentioned before, I think many of us have seen questions and queries around difficulties in dealing with LADOs and the inconsistencies across different areas, and particularly those arrangements for informal advice. And so hopefully we will see some changes in relation to that to ensure more consistency across the board there. And governance was another key area that the report focused on. And again, there are no surprises in terms of the rhetoric in terms of more effective governance based on openness to external scrutiny, transparency, honesty, and empowering governors to have those difficult conversations with the head or with the senior leadership team. And another issue around government, and this was highlighted in some, particularly in relation to some of the closed schools, was changes to prevent the sole proprietor being the DSL, so he can't be a judge and jury in relation to his own actions potentially there, which we saw, as I said, particularly in relation to some of these smaller proprietor-owned schools. And changes in the registration system for independent schools to make it a more rigorous process. Now, the fourth recommendation related to training and raising awareness. And so IICSA would like to see there to be accredited levels of safeguarding, and the highest levels, no surprises, again, mandatory for heads and the DSL. And another area where we were looking at training and awareness raising is in relation to those children with special educational needs and disabilities, and a review of the relationship, sex and health education provision, because there are particular difficulties around that cohort of pupils, particularly around sexualised behaviour. Now, the fifth recommendation related to inspection and monitoring. And again, no surprises, we were looking at issues of transparency with inspectors, particularly where referrals have been made to the DBS or the TRA. So we had examples of where schools had made referrals to the DBS or LADOs indeed, but the inspectorates were not aware of this. And so a school may have been adjudged on inspection as excellent, and then maybe a couple of months later there's been an unannounced inspection, and suddenly the school has gone from excellent to failing an inspection based on the same or similar information, but the inspectors were not aware of what was going on in the background. So I think we will see some changes around that for the better. Now, vetting, barring and teacher misconduct had a big, there was a lot of consideration of evidence in relation to this. It's always a difficult area. As a firm, we get lots of questions around these issues. And again, IICSA wants the government to close some of the loopholes around this to prevent offenders getting into schools. So, for example, closing some of the loopholes to bring people like TAs and learning support staff under the teachers' disciplinary regulations, and some amendments to keeping children safe in relation to grey areas around supervised volunteers, and again around proprietorial schools in relation to this loophole regarding children's barred list, so checks against children's barred list, and preventing proprietors and governors who are on the children's barred list from taking part in the governance of schools. There are also some recommendations specific to Wales that I won't go into in any detail in this course. I think these are all recommendations, and we've all seen all the white papers and the reports where there are recommendations. So time will tell whether they will be implemented. A lot of them are recommendations on a theme building on what we've seen in some of the religious organisation reports. And so I think we will see some of these recommendations coming in the near future. Now, we have been in contact with the DFE about how they plan to take that forward, but as yet, we haven't got the detail from them, but we will keep you up to date with that. And so what I'm going to do now is hand you over to Tabitha, who's going to take you to more of the practical application and the key learning points and how we can translate these for your particular roles in the schools. So over to you, Tabitha.
Thanks, Natalie, and thanks for the summary of the report. Essentially, one of the things that's important to know is the report is useful. It gives huge amounts of guidance, which will help to inform best practice. But as yet, it doesn't herald a change in the law or the regulatory requirements. I think it will. As Natalie said, it's made a number of recommendations for change, and what we will see is this constant evolution of safeguarding best practice. But many of you will want to reflect on that now to make sure that you're doing the very best to safeguard and protect your communities within your schools. Perhaps the most important learning point for me was what was said right at the beginning of this talk. When we started being involved with the inquiry asked for information about allegations or concerns of child sexual abuse without any time limit. They went back to the 1950s seeking evidence. And I think that there was a real perception that there had been historic wrongs, but things were better now. And one of the conclusions and the key conclusions from the inquiry is that things may be better now, but they're still not good enough. And that it's not appropriate to simply say, well, that was then, this is now. There is more that can and needs to be done in schools at this stage in order to protect children. So I think that's the key point that I took from all of this, but there are a number of others. One was the importance of survivor engagement. I've heard a number of victims and survivors give evidence. It's always painful. It's very clear that the sequelae from child sexual abuse can be extraordinarily profound and very long lasting. And that is the case to a certain extent, regardless of the abuse that has been suffered. So of the seriousness as others might perceive it in relation to that. The other thing to say in terms of the importance of survivor engagement is that many people felt that they hadn't been listened to, that they hadn't been supported, and that they hadn't been asked what would be helpful for them. And certainly, I know a number of schools who think and want to do the right thing, think that they can set systems for support in place and dictate what support may be available. And actually what a number of survivors have said is, well, actually, what's important is what's important for me personally, not for a group of individuals. And that some sort of therapy may work for one and not another, or at one time and not another. So really do think carefully about listening to victims and survivors. Perhaps surprisingly, The inquiry didn't give much guidance about that at all, and have said that they will pick that up in their final report next year. The next piece that I wanted to share was that piece of research that children with disabilities are 3 times more likely to suffer from child sexual abuse. And I think it's really important that we're aware of that, and that we take appropriate steps with that in mind. The inquiry has identified a number of high-risk schools by type. They did that through their thematic response. They talk about high-risk schools in particular the boarding and special schools, because of the isolation, practical and emotional isolation that children away from their homes may feel, and the challenges for children who suffer from a disability, and having the words to describe abuse, and being able to identify and report that, and again then after that has been reported, in seeing things through to a successful finding or prosecution. They also talked about other high-risk schools by type. So music schools, because of that real bond, the one-on-one tuition being common by somebody who is a leader in their field, and that very strong relationship that can be built through that process. In a similar way, there are risks with that one-on-one bond that some members of staff may have with pupils, from being perhaps a particularly charismatic or eccentric member of staff, and really fostering that sense of an individual being special and the relationship being special, which erodes some of the normal boundaries, and can lead to abuse. As Natalie said, some of the proprietorial schools have been singled out, in particular because there is this real recognition through the inquiry report of the need for checks and balances. And in some schools, you may have actually not just a head who's also a DSL, but may also be the owner proprietor of the school. And in independent schools, there being no requirement for an oversight board or an advisory board, although many would in fact have that. So the need for that adequate challenge. And there's also talk about in particular, the culture and leadership style of the head, and that a high-risk school by type is can be created by a very strong autocratic head who does not embrace challenge and reflection, and is more dictatorial, and people are then afraid to bring matters to their attention. One of the things that was very shocking in reading the report and the information that came to light about child sexual abuse is how much offending was done in what's called plain sight, where excuses were made for behaviour which perhaps challenged usual boundaries, and people were aware of those proximate relationships which in hindsight constituted grooming and the start of relationships, and yet those had not been called out. Now, Marcus Aruga and Simon Hackett have been researching issues relating to child sexual abuse for many years. Both gave expert evidence to the inquiry, and if you haven't read their research, then it really is essential reading. And we can send links to the reports, or you can access them from the inquiry website. I'm sure many of you will have heard Marcus Aruga speak. He's an independent safeguarding consultant who worked with the NSPCC for a number of years, and has investigated how offenders operate within institutions and how organisational cultures can be improved. He has made it very clear that organisational offenders in schools are an extraordinarily diverse group, and we can't say, oh, well, an offender will have this profile and then look out for that. It's a very diverse group. Some have an intention to abuse children before joining a school, others may not. Indeed, he talks about the categorisation of offenders as being preferential, where they have a conscious desire to abuse children. Opportunistic, where they're motivated to do so, but will perhaps undertake a sort of cost-benefit analysis before doing so. And situational, where there's no known prior propensity, and the abuse that they go on to commit perhaps comes about because of a combination of their life stressors and the organisational features in place. And of course, the reason that's really important is that historically people have over-relied on checks as being a test of whether somebody is suitable to work with children. And what we're really seeing is this direction of travel to, of course, checks being important, but really it's about behaviours. And the reason it's about behaviours is explained very clearly by Marcus Aruga, who talks of a slippery slope of boundary violation being something which then leads to abuse, either from the opportunistic sex offender who, once they get away with some minor infractions, is perhaps encouraged to push further, or the situational one who perhaps without the same level of intent goes through a similar process. And what Marcus Aruga says is that once somebody disappears down the slippery slope of abuse, it is very difficult, although not impossible, to come back up the slope and to restore the usual sense of normal boundaries and acceptable ones. So some essential research for you, which goes to the very nub of what the inquiry was investigating. And in fact, Marcus Aruga was asked to comment on all of the case studies across both phases, and latterly, at least, he, in relation to his report in phase 2, was very clear that the abuse that was investigated at that stage took place within school cultures, which he described as distorting usual expectations. He described the schools at which abuse took place at the relevant time as being an ecosystem that facilitated criminal acts. And he talked of the need for all schools to ensure that their culture and values are consciously shared by everybody to enable inappropriate behaviours to be addressed. Although the inquiry didn't spend as much time looking at peer-on-peer abuse, it did in particular in the residential special school environment, and it too endorsed Simon Hackett's research about harmful sexual behaviours and the framework and continuum, which was previously referred to in Ofsted's report on peer-on-peer abuse, and which again I would encourage you all to refer to. Again, I can share his research. In fact, we'll share links to the relevant reports with the follow-up to this seminar. The other piece, which is a key learning point, is that we really do need to work with local authorities. We quite often have a situation where either a school has had a bad experience of working with a local authority in terms of their willingness to help, or in terms of the availability to do so. And what is very clear is that the inquiry acknowledges that there are massive individual differences, and notwithstanding that, says that schools need to work with the local authority and find a way to do so. And it also talks about the importance of embracing challenge as an opportunity to review the school's arrangements and facilitate that culture of ongoing improvement. If we can move on to the next slide, please. So then there are some key actions, and what we've tried to do is to set these out at different levels to help you. One of the things that came from the inquiry report, not just this report, but many others, are the focus on protection of an organisation's reputation. And the inquiry have made it very clear that a proprietor's duty is to put the child or children first, and to do that before the institution. Their job is to provide oversight and active challenge. In fact, the inquiry has said in that context, governance should provide an additional layer of assurance by scrutinising safeguarding arrangements in a school and holding school leaders accountable for their effectiveness. Governors or proprietors must have some safeguarding knowledge and must also be provided with sufficient information about safeguarding issues which do arise, so that they can monitor whether policies are being implemented and whether those policies are effective. They talk of the relationship between governors and the head and SLT as being a cornerstone to good safeguarding practice. Now, with that in mind, what's very clear is that governors need to make sure that they have enough information, not only about policies and procedures, but about individual matters to enable them to perform the role. And I think that one of the things that is clear to us from the work that we do is that there is a tremendous variation in the amount of information that is shared with governors, and the way in which governors will examine that information. And we're seeing, not only through the inquiry, but also through the inspectorates, increased scrutiny about how that is undertaken. They need to ensure, proprietors need to ensure that you are accessing appropriate training. Much was made of the fact that there is no mandatory training for the governing body. I was surprised that the inquiry appeared to be suggesting that it's only the proprietor or the designated safeguarding governor who needs specialist training at the very highest level. I think that all governing bodies ought to have that access to that training, given their shared responsibility for it. And as Natalie mentioned, much talk about the fact that we need to have some consistent standards of training that is provided. There's also a duty to consider whether the resource allocated to safeguarding is sufficient, and with the increased expectations we're seeing at every level, I think that there is a need to check whether enough time and money is allocated to safeguarding in view of the best practice expectations that we're seeing. I thought it may be useful to share with you what Ofsted has recommended as principles for governance. So they have suggested that the independent school standards are changed so that the governors are required to be open to external scrutiny, to be honest and transparent within the governance arrangements, and to be able to have difficult conversations both internally with the head and senior leadership team and externally with perhaps the local authority or inspectorates. Those are really difficult skills, I think, and it's one of the things that we've done in terms of developing our own training resources from the inquiry report. So our effective safeguarding governance session is going to have particular focus on how to hold the head to account and how to have those difficult conversations. Our next seminar on that is on the 10th of May, if any of you are interested in that. And then if we move on to the next slide, please. We then move on to talking about the, excuse me a moment, key actions for heads. So the inquiry has made it very clear that they see the head as having primary responsibility for creating the culture of the school and ensuring that safeguarding is understood and prioritised. And one of the things that they did talk about was that whilst the role of DSL is key, that they didn't feel that an effective DSL could manage safeguarding by themselves, that it absolutely, they couldn't, if you like, adjust for a head who didn't fulfill their own obligations in that context. I talked about the fact that the inquiry had identified an issue with a head's leadership style, that an overly autocratic style was seen to be a risky environment as it deterred people raising concerns. And there's some guidance given about leadership styles, about the need to be open and transparent, which we've heard about a lot, but also about the need to be reflective. So that real push to reviewing matters when something has happened, and where appropriate, having external help in undertaking that review. So an example that's given in the inquiry is that if an allegation against a member of staff is substantiated, then there should be a ladder involvement in the review that's undertaken after the immediate matter has been dealt with. We talked about the ISI view that the relationship with the governing body and the head being a cornerstone. So heads really do need to prioritise the relationship with governors and with others who may be holding the school to account, making sure that the information that's given is true and that it's full and frank, using some Charity Commission terminology in relation to the way in which information is shared. Interestingly, one of the things that was considered with all of this is whether it would be appropriate to import a duty of candour to schools on sharing information. And at the moment, at least, the view is a view of the inquiry was that it wasn't necessary because they would achieve the same aim, if you like, by boosting information sharing between the different regulators, so that knowledge of concerns is shared more widely and addressed in that way. One of the other key actions for heads was in terms of ensuring that your DSL or your team of DSLs have sufficient time, resource and authority to perform their role. And while it was clear, and the inquiry expressly said that it's for the head and chair of governors to make decisions about whether or not to make referrals to the local authority, the impression that is writ large in the report is that if in doubt, an organisation should either refer or seek advice from the local authority about whether or not to do so. We've talked about those aspects and the key responsibility for heads. If we move on to the next slide, we'll pick up the specific actions for DSLs. And what was very clear in what was said is that the role of the DSL can be demanding and time consuming, particularly in large secondary schools, hence the need for governors and heads to be aware of that and make sure that it is appropriately resourced. So we've known for some time through the regulatory framework that DSLs have lead responsibility for safeguarding and child protection in the school. And they have a key role in developing the safeguarding in culture and ensuring that the voice of the child is properly heard. So in that context, I think the DSL ought to be thinking about what they are doing as a school to create and improve and develop the school's safeguarding culture. And I think also ensuring that the voice of the child is heard, and best practice within that is giving a number of different options for children to share concerns, either about the welfare of each other or about the conduct of adults towards them. Some would be in person, some through other routes, some internal, some external, some named, some anonymous, to really make sure that you're standing the best chance of hearing from children. There was a real acknowledgement that it isn't just a question of making sure that people are trained, but that safeguarding training must be targeted and effective. So it perhaps ought to consider being delivered through different medium, using reference to past cases, perhaps even to past cases involving the school, albeit on an anonymised basis, that you're making sure that it's targeted. There were numerous examples through the inquiry report of concerns being reported but not passed up through the safeguarding framework within a school, such that action was taken. but it often being maintenance people, cleaners, or others who noticed small infringements which didn't get passed up through such that action can be taken. I think it's important that those are flagged and people are aware of the role that they all have to play in ensuring an effective safeguarding culture within the school. The other thing is about ensuring that there are clear, properly implemented policies and procedures. In many of the schools that were examined through the course of the inquiry, the inquiry noted that there were deficient or inadequately explained policies and procedures, such that people they couldn't find the answer, or it wasn't clear what they should do, or that they didn't know where to go to find out what to do. So I think it's important that DSLs have another look at policies and procedures in light of what's been said. There's actually a very useful glossary of terms and terminology, so you may want to just double check the terminology that you're using to ensure that it's consistent with modern language. And of course, the DSL has a crucial part to play in ensuring that allegations and concerns are responded to promptly. And the inquiry has talked in many ways of the need to do that. They've talked about the need to put the victim first when you're dealing with allegations and concerns, and the need, if external agencies make a decision about taking no further action, for it to come back to the school and for appropriate action to be taken. There was also an interesting aside in relation to the piece about the management of allegations and concerns, about the need for independence of investigation. And the inquiry has said that in their view, straightforward investigations can normally be carried out by the school itself, but more complex ones might require an independent investigation. So no definitive guidance, but some useful thoughts when you're considering that aspect. And then, of course, it's the DSL's role to ensure that there is effective record keeping, and that record keeping not only allows trend analysis, but that trend analysis is undertaken. And I think we're getting to a stage now where it's very difficult to perform that role without electronic record keeping systems to enable reporting to be made and managed, and that trend analysis to be automated insofar as it can. If we move on to the next slide, please. Then, of course, we've got the key actions for staff, that awareness, reinforcement of the fact that all staff have a critically important role to play, and the need to be an active bystander, the need to listen, and the need to take appropriate action and make appropriate reports and referrals. And I think for many, there's also that expectation about keeping proper records, and I think it's useful to make sure that you actually give staff training on how to keep proper records, and that can be done alongside use of safeguarding management systems, or separately, but the imperative of record keeping as being a cornerstone around safeguarding and improving safeguarding cultures is key, and it starts at the bottom with people knowing what needs to be shared and how. And if we move on to the next slide, then it's consideration of what next. Natalie's talked about the final report next year. The inquiry has already told us it will cover mandatory reporting. There was perhaps less within the investigation report than I thought there might be in relation to mandatory reporting. Much support for the fact that, well, there is an obligation to report as things are at the moment through keeping children safe in education and through most schools' contracts and code of conduct. At the moment, of course, there isn't a criminal sanction for failure to do so, and there are considerations being given in relation to that. More about what we can do to support victims, and more expected about the vetting and barring regime. I have, in going through the report, made a list of all of the recommended changes to keeping children safe in education and the national minimum standards for boarding. I think that we will see changes to the regulatory frameworks, and I think it will be difficult for them to wait until next year. I think that we will see yet more consultation and significant change to guidance this September, with that in mind, in relation to the points that Natalie and I have discussed today. I think there will be changes to the record keeping requirements. You'll remember that we were all told when the inquiry opened that schools should keep any records relating to child sexual abuse, at least for as long as the inquiry was ongoing. We're starting to receive some questions about, well, has that changed now this investigation has completed? No, it hasn't. And as yet, the inquiry hasn't given any strong guidance about record keeping requirements. My own view is that that we are likely to have a requirement to retain records now that the usual limitation periods on claims has been extended, and now that we're seeing so many more people reporting non-recent issues, and the police and CPS taking action later. So my view would be, if in doubt, retain, as things are at the moment. We are going to see increased scrutiny of inspectorates. The inquiry was very critical of the dual inspection process for independent schools at the moment, and I suspect we'll be looking into that. What we are seeing is also increased scrutiny by inspectorates. So, as Natalie mentioned, one of the things that we saw in the face of organisations where offenders were abusing children in a school were some glowing inspection reports from both inspectorates. And what's clear is that an inspection by an education regulator is not of itself enough to really get to the nub of the school safeguarding arrangements. And I think that the government will be asked to look at that and see what it can recommend as a consequence. And the other piece that I've mentioned on there is the greater expectations of governors and proprietors and the need for training to facilitate that and for them to really undertake their check and balance role. I mentioned there were some things which were not covered in the way that I thought they would. The first was mandatory reporting and the duty of candour I mentioned earlier. Very little about all of that. Very little about Marcus Aruga's low-level concerns theory, which of course has now been introduced into keeping children safe in education, although there seems to be a general support for it, and in fact a criticism of the absence of sufficient guidance in keeping children safe about how that should be implemented. So we had those bits. Actually, very little on peer-on-peer abuse, which emerged as an issue after the terms of reference for both the inquiry and this investigation were set. But plenty in there in terms of food for thought, and plenty more we can all be doing to make schools safer. Okay, so do we have any questions?
So we do have a couple of questions, and I'm not sure we're going to get through all of them in the next 2 minutes, but perhaps if we can just deal with them on a theme. So we do often get quite a lot of questions around record keeping, data protection, and that kind of thing. And questions around how do we balance a detailed knowledge of safeguarding case against data protection laws, what should we record and how should we record it, particularly in relation to low-level concerns. And, you know, essentially, schools should use their common sense in relation to information recording. KCSIE says that fears about sharing information shouldn't stand in the way to safeguard and promote the welfare of children. So for many, many reasons, it's so important that proper records are kept and that data protection is not used as a bar to sharing that sort of information. Now, some schools will have many different ways of doing this. You know, it may well be that it works to have some standard forms, some standard information, and training for all. I know Tabitha's mentioned this alongside, you know, your various safeguarding platforms. You know, just basic training on what constitutes a record, what you should retain. But certainly, subject to what you say, Tabitha, my view would be that you record as much as you need to, the basic details, what action you're taking, who it's being referred to, and that's a living document, or that you keep all of those records together in case of further scrutiny by inspectorates, local authority, the police, or others, and that data protection really shouldn't stand in the way of that.
Thanks, Nat. Did we have another question? I think I'm very happy that we stay and answer the questions. If you do need to go, I completely understand that, but I'm happy to stay on for another 5 minutes and keep going if you are.
Yeah.
So we had another question, didn't we, about reporting of low-level concerns?
Yes.
And I don't know if you're happy to answer that one too.
Yeah, I mean, it's you know, again, on the same theme, that low-level concerns is covered, as everyone would know, by keeping children safe in education. All low-level concerns should be recorded in writing. And again, common sense, it should record the details of the concern, the context, and the action taken. And I think where we see schools fall down is that the action taken part is not necessarily covered. So we've got some really good records about what happened, but there's no record of actually what was done in the context of that information. And then in years to come, we asked a simple question, well, what happened? And staff have moved on, and nobody actually knows the answer to that. And so there are questions around the individual making a low level, raising a low level allegation as to the extent to which they can remain anonymous. Again, it's a common sense judgment here that should be respected insofar as you're able, but that's not always practical or possible. These sorts of records obviously need to be held confidentially, and they need to be reviewed on a regular basis so that potential patterns of concerning, problematic or inappropriate behaviour can be identified. So the value of these records is not necessarily in relation to the individual concern, it's often in relation to the pattern of behaviour.
Thank you, Natalie. So some other questions. One I can deal with very simply, which is when can we expect the changes to the statutory guidance? We don't know as things are at the moment. I think that they are likely to be changed significantly before the final report, on the basis that the statutory guidance to which we refer most commonly is particular to education institutions, and we're unlikely to get more guidance specific for those organisations before the we're unlikely to get any more in the final report. So I'll let you know when we know more. That's where we are on that. Next question was, who should review the low-level concerns log maintained by the head? Is it appropriate for the DSL to review? That will depend on the school's own delegation arrangements for safeguarding, but certainly many schools will have arrangements in place where the head and DSL will, together perhaps with their safeguarding committee, think about low-level concerns and discuss them in order to do that trend analysis that we've spoken about. And the final question that I have here is, how would governors assess whether the resources allocated are sufficient? I think primarily you will assess it with reference to your outputs, and whether you and other stakeholders are satisfied that they are appropriate, but you will also be looking at whether the arrangements you have in place are mirroring what is available at other schools of a similar nature. And if it would be helpful to discuss that in more detail, then I'd be very happy to do so.